Afternoon and welcome to the Rapid City Legal and Finance Committee meeting for Wednesday, June 1st. And Maggie, if we could begin the meeting with a roll call and determination of quorum, please.
Drew, here. Nordstrom, here. Laurenti, and Scott.
Here.
And Lewis.
Thank you. Now's the time to adopt today's agenda. I'll entertain any comments from seated committee members for any additions, deletions, modifications on the agenda as presented us today. If there are none, I'll entertain a motion to adopt the agenda.
So moved. Second.
I've got a motion by Laurenti to adopt today's agenda as presented, second by Nordstrom. Any further discussion? Seeing none, all in favor?
Aye.
Any opposed? The agenda has been adopted. Now is the time for general public comment. This is a time for any member of the audience to address the committee today on any item currently not on today's agenda. I currently have no speaker request forms for any general public comment. Am I missing anyone? Seeing none, general public comment is now closed. Now we'll go on to public comment for consent items. Today's agenda has consent items 1 through 15. I currently have no speaker request forms for any of the consent items. Am I missing anyone in the audience? Seeing none, public comment on consent items 1 through 15 is now closed. At this time, I'll consider any committee members weighing in to consider any consent item separately from items 1 through 15. Chair recognizes Alderman Nordstrom.
Thank you, Madam Chair. Item 12, please.
Item 12. Chair would like to recognize Alderwoman Drew.
Yes, I'd like to pull item 15, please.
Number 15. Are there any other items that any committee member would like to consider separately? If not, I'll entertain a motion to adopt today's consent items 1 through 15, except items number 12 and 15.
So moved. Second.
I've got a motion by Laurenti, second by Nordstrom, to approve items 1 through 15 on the consent calendar, except items number 12 and number 15. And a comment from the chair before we vote on this. There were a couple other items that I have questions on, but in deference to the committee members today, I will pull those items Monday night, but just so that the staff has a heads up. They are items, I have some questions on 4, 5, 11, 13, and 14. But that being said, before the committee today, all in favor?
Aye.
Any opposed? Items on the consent calendar 1 through 15, except items 12 and 15, have been approved and will go to City Council with a recommendation of approval Monday night. Item number 12. Item number 12 is the updates, or to approve the updates to the non-union employee guide. Chair would like to recognize Alderman Nordstrom.
Thank you, Madam Chair. If I can call Allison Cream. Sorry, Allison.
Hello, Allison. If you'd please state your full name and your affiliation to the city, and Alderman Nordstrom has some questions.
Yes, Allison Kreilman. I'm one of the assistant city attorneys.
Thank you, Allison. I appreciate your answering all my email questions, and I was able to figure out a lot of the comments that you made in there and addressed them very well. Thank you very much.
You're welcome.
The only concern that I have, and it remains a concern of mine, is and I need your help on clarifying this so I'm totally understanding what it is, has to do with the termination of employees that are designated as appointees by the mayor.
Okay.
Can you give us a little background on that and why the change?
Certainly. So at one point in time in the non-union employee guide, there was an employee severance plan, and it applied to mayoral appointees. So those positions that were appointed by the mayor with the approval of the council. And the purpose of that plan was to protect those employees in situations where they would be terminated not for just cause. So often those were department director positions, and they were, as you know, sometimes those positions can be subject to the politics of the day. And so in order to attract and retain high-quality employees, that protection was in place in case that should happen with a new administration coming in or something along those lines. As time progressed, The employees who were benefiting from that plan dwindled because department directors, as you may remember, all have contracts now with the city, and their severance plans are laid out in the contracts. However, the City Council did pass a resolution to grandfather in any employees who were not benefiting from a contract with the city and thus having a severance plan in their contract. And so at this point in time, there's only 3 individuals who are left under that quote-unquote grandfathered status. That is myself, Wade Nyberg, who is with the city attorney's office, and Dale Tech, the city engineer and acting public works director and acting community planning director. So since there are only 3 individuals left and it's not a plan that will continue on after those 3 individuals, who knows what the future holds. I plan on staying with the city at this point in time, but in any event, rather than have those individuals named in the guide and have the plan in the guide when it only pertains to a very limited number of people, it's being taken out, and the plan and the resolution that was passed, along with a memo and minutes from the council where the action was taken, that the resolution was passed, will be placed in the personnel files of myself, Wade Nyberg, and Dale Tech, so that should the plan come into play, it will be clearly set out in their personnel files that they are to benefit from the plan.
I'm trying to recall of reading that contract the other employees have. You, Allison, are not under the contract currently. Am I reading that correctly?
That's correct. The 3 individuals who remain grandfathered under the plan do not have employment contracts with the city like the department directors currently have employment contracts with the city. So they have the department directors have a severance plan that is set out in their contracts.
Yes.
And those of us that are grandfathered under the previous severance plan don't have those contracts, and that's why we're grandfathered.
I guess this is where it's coming upon the issue for me is totally understanding how that severance package works. The contracted employees versus the grandfathered employees. And I just want to make sure that we're still playing on an equal playing field, if you will, that each one is still getting treated similar, and that there's not a preferential treatment given to one group versus the other. Am I reading that correctly, that there is no preferential treatment?
There isn't preferential treatment to my knowledge. I guess not having recently read one of the department director contracts, I would maybe point to, I'm not sure if Joel Landine, our city attorney, has information about he's a beneficiary of a contract, but under the grandfathered plan, the maximum amount that a person would be allowed, it tracks the Track B sick in the non-union guide, also known as short-term disability, and so depending on years of service, there's an up to 6 months of salary that is paid out at the time of a termination, not for cause. And as to how much those that have contracts receive, I don't have that information at my fingertips, but Mr. Landine might.
Madam Chair, if I may.
Yes, you may
May
address
direct
the
the
city
questions
attorney.
to City Attorney. Joel, do you understand the question? And then,
Yeah, I'm trying to remember. I think that we did make some changes to the severance plan with the contracts, one of which being that rather than have the council decide whether or not a department director is fired for cause, because that inherently makes it a political question, we switched it so that because it was under an employment contract, now it, for those with an employment contract, it becomes a matter of contract law. So if there's a dispute over whether or not it's cause, it would go to the courts rather than to the city council. With the 3 individuals who are grandfathered, because they don't have a contract, we can't make it a contractual issue. You know, the reason the severance was for, in the original non-union guide, was for employees who were appointed by the mayor and confirmed by the city council. So the change, one of the philosophical changes that was made when we moved to contracts was that assistant city attorneys and things, rather than being appointed by the mayor and confirmed by the city council, they would just become employees like any other city employee who are hired, and only the department directors would be appointed by the mayor and confirmed by the council. So the idea was that they would be protected, I guess, by the fact that they were just normal employees who weren't confirmed by the mayor or appointed by the mayor and confirmed by the council, and didn't need contracts and things like that. But because there were 3 employees that had previously benefited from this, who had been appointed by the mayor and confirmed by the council, again, those employees were grandfathered in. As Allison has stated, when we looked at going forward, I think it's confusing to have the severance when it only applies to 3 employees in the non-union guide, but we wanted to make sure we had it documented, so if there was ever a question with one of these 3 employees, that it would be clear the council, when they made the decision to go in that direction previously, they had grandfathered these 3 employees in, so that's why we took the minutes from that meeting along with the terms of the policy in effect at that time, and are putting that in those employees' files so that everyone knows. But now, moving forward, the non-union guide will not have that in there, so there won't be any confusion about who that applies to or why it's in there.
Thank you, Mr. Lindy, and I really appreciate the staff working very hard on this, coming forward on it, because in previous times when a mayor would come into office, newly elected mayor come into office, and he would go back, yes, all of them are males, so he would go back to the individual that was being, shall I say, confronted at that time, and asked the employee to remove all their items, and you're done. And so I appreciate your working hard so that we're not going through that type of experience again. So again, thank you for all that effort. Thank you.
Thank you. There are currently no other speaker lights. I did have one question on this, Allison.
Yes.
Can you please explain the difference between city-observed holidays and personal holidays?
So the city observed holidays are those that are set out in the holiday section. So 4th of July, Memorial Day, Christmas Day, Thanksgiving Day. A personal holiday is one that is of the employee's choosing. And so that can be used on any day of the year. However, a person does need to be employed with the city for at least 90 days. It is a benefit that has to be earned. And so in order to be able to use that personal holiday, say there's a particular Friday coming up that you want to call it a 3-day weekend for yourself as a city employee, it's not an official, an observed holiday, as you indicated. You can use that personal holiday if you haven't used it yet, as long as you've earned it. So it's really... it's called a personal holiday because it's personal to you. You choose the day, provided you've earned the day.
All right, thank you.
You're welcome.
And Joel, so what I'm understanding is that this personal holiday is 1 day after an employee has worked with the city for 90 days.
Correct, and I would point out the city has a little different holidays, so overall we have the same holidays, number of holidays, I believe, as most government employees, but instead of observing Native American Day, Martin Luther King Day, and President's Day, we observe the Friday before Easter, Good Friday. We have a personal holiday, and we get the Friday after Thanksgiving. So the personal holiday is in lieu of one of those other 3 holidays that most other government employees get.
Okay, so the 3 holidays that you mentioned that usually are observed by other governmental agencies, 2 of them are covered, and then the personal holiday makes up the 3rd one that the employee can choose to take off
Correct.
that year. And then it's renewable every year?
Yes, every year you get it. It's just so you get the same number of basically holidays as everyone else, just for whatever reason. It's been this way since for the 12 years I've worked for the city. We just observe those 3 we work on those 3 holidays, and we just get 3 alternative days.
All right, thank you. Chair would like to recognize Alderwoman Drew.
Do we have a motion?
No, we do not have a motion.
Move to approve?
Got a motion by Drew to approve, second by Laurenti. Alderwoman Drew, you still have the floor?
No further comment, I yield.
All right, no further comments, no further speaker lights. We do have a motion to approve. All in favor? Aye. Any opposed? Motion carries. Item number 15. Item number 15 is to authorize the mayor and finance officer to sign the development agreement for tax increment district number 77 between Black Hills Power Incorporated and the city of Rapid City, South Dakota. The chair would like to recognize Alderwoman Drew.
Well, I'll be voting in favor of this. I have had some concerns expressed by constituents, but I'd like to remind the city and also these council people that not too long ago, a TIF was given to Cabela's, and I don't think we could argue the fact that they're a very successful company and probably didn't need our help, but they held a gun to our head and said, either you give us a TIF or we're going to spearfish. And nobody, I don't think anyone could argue either that it's been a great economic impact for the city of Rapid City to have Cabela's here. I feel the same about Black Hills Power and Black Hills Corporation. I'm very glad they chose Rapid City as their headquarters. It's going to be an economic boom for our city for, I don't know, decades. And that they want to have a tax increment funding for increasing the amount of room they have for training and create 50 jobs, first of all, at $85,000 apiece. Those are exactly the kind of jobs that we want here. We don't want more service sector jobs. We have plenty of those. These are the kinds of things that will help us keep our college graduates in Rapid City. Hopefully the School of Mines people can get that kind of job with Black Hills Power. They're going to grow this to, Black Hills Corporation. They hope to grow this to 150 people at their training center, so I'm going to support it. But I do have a question. Is someone here from Black Hills Corp or Black Hills Power?
If you could please state your name and your affiliation to the city, and Alderwoman Drew has a couple questions.
Sure. My name is Jafar Karam, and I'm Director of Corporate Affairs for Black Hills Corporation. Live here in Rapid City.
It's a pretty simple question. It says here Black Hills Power, Inc. I know that Black Hills Power has just gone through a name change to Black Hills Energy. So do we need to make some kind of change there, or is that the corporate entity that we're working with here?
Good question. That is actually the legal entity, and that remains the legal name. Even for Black Hills Energy, we've changed the trade name essentially.
Okay,
but legal documents remain the same, so that would be the proper.
I wanted to be clear on that before we went forward. Thank you.
Sure.
Chair would like to recognize Alderman Nordstrom.
Thank you, Madam Chair. First of all, if I may make the motion to approve.
Second.
I've got a motion by Alderman Nordstrom to approve, second by Drew. Alderman Nordstrom, you still have the floor.
Thank you, Madam Chair. And I know there's a great deal of community discussion over this TIF coming forward on it. And some of the reasonings that I've been hearing out in the community aren't well founded, and the rationale that I'm hearing, or the argument that's coming forward, is the status of the corporation that Black Hills Power is. And I'm not in favor of allowing any discriminations at this point. So that's the concerns that I'm hearing out in the community, is that Black Hills Corp is large enough and they can handle it on their own. But I don't want to get into the area of starting discrimination practice on who's going to get a TIF and who isn't going to get a TIF. So that's the reason why I'm supporting this TIF. Thank you.
Chair would like to recognize Alderman Laurenti.
Thank you, Chair. I guess the first thing I really have to say about this is some of the comments you've already heard. The fact of the matter is this is a corporation, a multi-billion-dollar corporation with a CEO. Just to put this in perspective, the CEO made $10 million over the last 2 years, which would easily pay for this TIF and still allow for $1.3 million for that CEO over those same 2 years. That's just perspective. The jobs are not tied to the TIF costs at all. The jobs have nothing to do with the TIF costs. So for us to say something about the jobs and that this TIF creates the jobs, they do not. The TIF costs are related to all kinds of other things other than the jobs. The jobs are coming to Rapid City because this corporation finds that it would be economically positive for them to move those jobs to Rapid City. If this company or this corporation did anything other than something that was in their best interest as far as these jobs are concerned, that would not be good for them or the people who are their stockholders. So these TIF costs, these TIFs keep getting tied to these jobs, but the fact of the matter is these jobs are coming to Rapid City because it makes economic sense for the corporation to move them here. They have nothing to do with the TIF. If you look at the TIF costs, they don't say 50 jobs. These jobs are coming here regardless. So it's very misleading, and unfortunately, even in the agenda item, they talk about the jobs, and it's unfortunate that the taxpayers are being misled. I will not support this TIF because this corporation is building in an area where, for one thing, the things covered by the TIF are not regional, do not have a regional impact. There's some sidewalks behind the business. Those are all things that will improve the culture and the area of this corporation. They're for this corporation. They should be paid for by this corporation. They should not be part of this TIF. And so I will not support this. There are other ways that the city can increase development or encourage development, but nobody wants to talk about that. We've tried to talk about it before, but it keeps getting tamped down. I'm hoping that in the next year that we're going to have a conversation about this because there are better ways to do it than to give these TIFs to corporations, including Cabela's, which was a very bad TIF, and to use that as a reason to then approve another bad decision is a bad decision. And so I will not support this TIF. I yield.
Thank you. And if I can take a moment as the chair to also make a comments as well. I will not be supporting this. I did not support the approval of the TIF when it came before City Council. However, I did approve it when it came before the TIF Commission because I also serve as one of the city liaisons before the TIF Commission. And the difference between then and now is that when it first comes before the TIF Commission, it is brought with the idea of, does this make sense? And does it make sense on an economic or depressed area or infrastructure criteria? And the information that was brought to us at the time, I voted yes because it did look like it was a candidate for that, and I'm not necessarily saying it's not a candidate today. The reasons I'm voting no against the agreement and the reason I voted no at the City Council meeting to approve this is because I have an issue with the formula that was used to generate the finance charges on this one, and also I do believe that the city has alternate means through economic development to pursue, and some of those items were discussed, but they were not pursued, and the TIF was also pursued and kind of applied for and has kind of come through City Council. I feel that the City Council, the majority of members, this is just my personal opinion, are going to support this because they voted for it at the original one, but I did vote no, and I will continue to vote no on this for the reasons that I've stated. But that's probably going to make a vote of 2-2, so after we take this vote, if I can entertain a motion to send to council without recommendation, just trying to give everybody a heads up there, we might be able to get a positive vote for that, and we can discuss it Monday night. Are there any further discussion? Chair would like to recognize Alderman Laurenti.
Thank you, Chair, and I'll take that obligation to make a substitute motion to send to council without recommendation.
I've got a substitute motion to send to council without recommendation by Alderman Laurenti, second by Drew. We are now voting on sending this item to council without recommendation for Monday night so it can be discussed and voted on. Any further lights? Seeing none? All in favor? Aye. Any opposed?
Aye.
We have sending it to council without recommendation. The vote is 3-1. Alderman Nordstrom is the no vote. That is all the items on the consent calendar at this time. We are moving on to non-consent items. Non-consent items today on the agenda are items 16 and 17. Items 16 and 17 have no speaker request forms at this time. Am I missing anyone for public comment on items 16 and 17? Seeing none, public comment is now closed. We're moving on to item number 16. Item number 16 is the second reading and recommendation of ordinance number 6114 regarding the supplemental appropriation number 2 for fiscal year 2016. I've got a motion by Nordstrom to approve, second by Drew. Any further discussion? Seeing no lights. Pauline, as the finance officer, if I can just pose one question. Any changes between first reading and second reading?
There were, and unfortunately, because the internet is not working, I cannot access and tell you exactly what it was.
Do you remember a roughly dollar amount or what it was in reference to?
My recollection is that it was a transfer from one fund to another, but I honestly cannot remember what it is.
All right.
My apologies.
Thank you. So we'll just give a heads up to all city council members that there is a change between first reading and second reading. If I don't have a substitute motion, the motion currently on the floor is still to approve the second reading and recommendation. Seeing no further lights for a substitute, all in favor?
Aye.
Any opposed? Motion carries 4-0. Item number 17 is the introduction and first reading of ordinance number 6122, adopting section 16.090 of the Rapid City Municipal Code, requiring the registration of vacant residential properties. The chair would like to ask our city attorney, or a city attorney, or someone from Community Resources, or someone's approaching the podium. If you could please state your name and your affiliation to the city and give us a brief explanation on why this is coming before the city.
Hi, I'm Jess Rogers with the City Attorney's Office. The idea behind this ordinance is we have these properties in Rapid City that go vacant. Usually the most common reason is they're in foreclosure. They're often owned by banks who are out of state. Sometimes I found recently they're not even registered to do business here. And no one mows the grass, no one cleans up the yard, code enforcement is constantly there. There are some of these properties that they just mow all summer. And we can assess that and, put that against the property. But when it's in foreclosure and these banks, it's sort of being transferred between banks, it's hard to track anyone down to deal with it. A lot of times they become attractive nuisances because you can tell it's obvious no one lives there, so people are breaking in and you get squatters and it becomes a police issue. It's really hard for us to deal with when we can't find an owner. Or if we get a name and there's no one in Rapid City, there's no one we can cite criminally. It's very hard to go to another state and take legal action against them. By the time we got anything going, they could hire an attorney and fight about venue, and it would be owned by someone else by the time we were able to get anywhere with a court procedure. So the idea behind this ordinance is if there's a property that's vacant in Rapid City, either because it's going through foreclosure or just for any other reason, the property owner has to register with the city. And what we really want from them is we want to know who the owner is, and we want either a natural person or a business entity in South Dakota. So that if there are problems, we're basically saying we just want to know who to talk to about getting the grass mowed and getting things cleaned up. So for general code enforcement purposes, it gives us a South Dakota person or entity to deal with. The other thing is, because when properties are vacant, there's sort of an increased risk within the community. We've put in an accelerated time frame so that not only do they have to comply with all the regular code enforcement regulations regarding, grass and debris and things like that, we've sort of listed some extra steps they have to take to not have mail and circulars building up so that it's obvious to the community that this house is vacant, that if there are broken windows or anything, they have to be boarded up. And we've put in an accelerated time frame of 3 days. Because once you've told us who you are and we know how to notice you, then we feel like that's enough time if you're a bank or some kind of, or just any property owner really to fix the problem. Otherwise, we want to be able to abate quickly to keep these vacant properties from becoming problems for the police or for the community or just a constant hassle for code enforcement. So we want to be able to act more quickly. That's the gist of it. That's the reasoning behind it. If you have any other questions about the details, I'd be happy to answer those too.
Thank you, Jez. Chair would like to recognize Alderman Nordstrom.
Thank you, Madam Chair. Jessica, I really appreciate all the work that you put into it. And it was not simple ordinance to put together that you worked on and with code enforcement, putting this together. What brought this all about for me was the property management the city is being placed in because of primarily the financial institutions. We're just letting the property go, and we, the city, had to do the property management for these different various properties throughout the entire city. Then collecting the lien on that afterwards was impossible or near impossible. In a lot of cases, we were not even able to collect that lien in a timely fashion. And there's some other issues on it, but essentially for me, about once a month, we could go through all these abatements that we were checking off each month and looking at the liens, and invariably there was at least one financial institution on there on just about a monthly basis. So, and the next step is to make contact with these financial institutions so that they are aware that this ordinance is coming forward, so we aren't blindsiding them or we're giving them a heads up to deal with this in a proper fashion. So again, I thank the staff for working on this so diligently and coming forward with this ordinance. Appreciate it. Thank you.
Thank you, Jessica. There's no currently any lights up here, but I did have a couple of questions in regard to this ordinance. Again, I applaud staff working on this. I know it's a real issue. My questions are more pertain to, I'm not sure I see the benefit of this ordinance. So let me start with, because reading the ordinance, we're going to create an ordinance where any mortgage company or anything else that have the vacant property for 3 months, they have to notify the city and pay $50, and then annually, if it still hasn't sold and they still have it, they pay another $50. Nowhere in the ordinance did I see what happens if they don't notify, because I don't see any force that makes them register with the city. So what kind of enforcement is there we already have this issue, and we have institutions that are not in South Dakota. What's going to make them do this? Or is this just passing this ordinance to hope they do?
Well, and you have a good point, and the problem is it's really hard for us when they are out-of-state businesses. We can take legal action, but they can drag it out, and any bank is going to have an attorney. They're going to have legal counsel that are going to know how to drag it out, how to get us in court where they are rather than where we are. You make a valid point. It's hard for us to have any real teeth because we're limited by state law on what we can do. We're hoping, I guess, that if we get the word out, they will voluntarily give us a name or someone that we can deal with. And a lot of times, when we do get in touch with the actual owner, they do cooperate to some extent. So I am hopeful that some of them will. And, if we've got the same players, if they give us a name once, even if they don't give it to us for the next property, if we know who they are, we can serve them. The idea behind it really is that, as Alderman Nordstrom mentioned, a lot of these properties, it's not that they're really trying to avoid us, it's just that they don't feel like paying someone to mow the lawn, and it's just a hassle, and we don't really go after them. We just put the liens on the property. So we're not even really asking them to do much, I think, from our perspective now. Whereas if you do pass this ordinance, if we can get a name of someone in South Dakota, a lot of times if you can issue a criminal citation, even if it's a $120 ticket, just the hassle of making them show up in court to defend a criminal citation will get them to say, hey, you know what, we can afford to pick up the phone and call someone to mow the grass, if that's what this is all about. And I've just had a lot of success in citing businesses and people criminally just because that extra hassle, they say, okay, you mean it, you really do want us to mow the grass. So you're right in that it's still hard for us to, if they just refuse, we don't have a lot of teeth, but if they do comply, if we get the name for a contact person for one bank, then we've got that name for properties going forward. We are hopeful that once we have this in place and can say, yeah, we are going to drag you into court and just create a hassle for you because you're creating hassle for us because we don't want to be property managers.
Okay, so am I understanding you correctly that by passing this ordinance, you can now take them to court for a criminal citation, and we do not have that option today?
We do. You're right, we do. This would be an additional penalty. There's an accelerated time frame, but you're right, we still need them to basically voluntarily give us someone in South Dakota if they're not a South Dakota entity. So it's an additional citation, but you're right, we still don't have any teeth in terms of forcing them to give us a name of someone in South Dakota. We're just basically asking.
Okay. Thanks for the clarification. And then my one other point, because it's kind of buried it's mentioned at the beginning and then it's buried towards the end, is that we're also requiring property owners, not mortgage companies, but viable, real people, property owners, that if they have property, a residential property, and it's vacant for more than 3 months or anticipated to be more than 3 months, that they also have to pay a $50 fee and register with the city. Mm-hmm. Everything that I've heard you say today, I understand about non-resident mortgage companies and banks. What's the reason for penalizing property owners within the city to also pay a $50 fee to register with the finance office?
Well, it's sort of the same reasoning in that if you're anticipating a property being vacant for 3 months, and we thought about the time frame because we didn't want it to apply to people who are going on vacation, on extended vacations, but generally it was anticipated that these would be other landlords or properties that are going to be vacant. the issue is they have the potential to create the same nuisance in terms of being attractive to people in the neighborhood when they see this house is vacant. It's been vacant for some time. There's 3 months worth of flyers on the front door. People start breaking in. It becomes an issue for the police department. So basically the idea is we just want to put people on notice that if your property is vacant, you need to take care of it and make it look like it's not vacant so that you don't get people, breaking in, and you don't get squatters. You need to board it up if it needs to be boarded up. Just sort of an additional tool to say, we have all these vacant properties in Rapid City that do become a problem. People just keep breaking in because everyone in the neighborhood knows nobody lives there. That's what we're trying to cut down on. And like I said, we thought about the time frame because we don't really want it to apply to people who go to Europe for the summer or who just vacation for extended periods of time. The idea is that we want to deal with these properties that are rentals that are not occupied.
So why is it not specified in here, a rental versus, to kind of, there's a lot of people in Rapid City that they're snowbirds, they do go south, or they go to Europe, and for an extended period of time. So again, I'm using the word penalize because I can see where these people, if they have to now come in, because those are most likely your law-abiding people. So I see them as being penalized to have to come in and register that and pay a $50 fee.
You're right. To some extent it is. I guess the thought is just that if it's going to be vacant for more than 3 months, it has the potential to become this neighborhood nuisance. I will say that when we talked about this, this is a requirement, but it's not something that we're going to be able to police. It's something that would come to our attention because the grass isn't mowed or because it's been breaking in, it's getting broken into and PD is notifying us of an issue. So it's not something that we'd be driving around looking for vacant properties. So if you were gone for 6 months but you took care of your property, realistically, we would never know.
Okay. I do have another speaker, so the chair would like to recognize Alderman Laurenti.
Thank you, Chair. I'm glad you're answering this question because this is really almost a follow-up to her line of questioning. So what you're saying is the enforcement is really a lot like code enforcement on this. We're going to enforce this $50 fee when we get a complaint because a home could be a nuisance, because it's vacant, they didn't cut their grass, they didn't shovel their walks. We will then check. Is there something in code enforcement where they'll be checking for this $50 fee then?
Honestly, when we discussed it, the idea was that when we get these complaints, we'll contact the property owner and say, hey, you know what, we have this requirement, register with us, before we go to citing them criminally for not already being registered. We're not out to get people, we just do want people to comply. And again, it would be, as you said, like normal code enforcement, where they see a property that's a problem or they get a complaint in a neighborhood on a property and then we try to track them down. I know the ordinance doesn't specifically say that. We could add a notice provision but.
So my last question then is to the heart of why we're doing this. If you can give that to me in just a short summary. Why are we doing this? Why are we charging this fee? What is it going to cover? Is it covering some expenses we aren't recovering today, or what is the purpose for it?
The purpose for the fee or the ordinance generally, or
both?
For
the fee, which really supports the ordinance. So,
for the fee, just to pay for the cost of administering this, of the additional paperwork of dealing with registrations. I assume that would go through finance like the other licenses and things that we deal with. Honestly, with the fee, we sort of talked about what an appropriate amount would be. We thought that might be an issue that might need to be negotiated because I'm not sure, honestly, what an appropriate fee to cover the cost of the program would be. Barb might be more qualified to speak to that, I'm not sure. But that was the thought, just the additional paperwork of having this registration that's required. And in a foreclosure process, it's anticipated that we would need to follow up because it would change hands. We put in here that, if you are registering a property that's in the foreclosure process, but you're selling it, but maybe you're not selling it to an owner occupant, but you want your name off the list, they would submit something to the city and then we'd have to, track down the new person. So that's the thought behind the fee.
it still doesn't make sense. I still am having a problem with the premise of the ordinance. What is the problem today? What is this fixing? Can you answer that?
Sure. The problem is that we are becoming property managers for vacant properties in ways that we don't want to. Code enforcement doesn't want to mow a property all summer because it's sitting vacant. So we're trying to get property owners to come to us. Go ahead.
Let me interrupt you then. Because you're saying the enforcement arm of it really is going to come from complaints, which is the same problem we have with code enforcement of lawns not being, which is where this is going to come from. So how does this improve that situation when in reality it really is coming from the fact that we have another code enforcement issue. So I don't understand how this helps the issue, except that it tacks on some new fee. Other than doing that, I don't understand how that is going to help the situation.
Given the problems that we've discussed with out-of-state banks voluntarily complying, the idea is that it'll speed up the time frame so that now, instead of code enforcement having to send out a new notice each time you get a complaint about the grass, you get one. The first time we find out that your property is vacant, then you have 3 days, and from then on, we're just going to abate. Once we know that your property is vacant and you're registered with us and we've given you notice, if you're not going to take care, we want to sort of speed up the process if you're going to force us to do that. Also, again, this is the additional criminal penalty, assuming that we can get a South Dakota person, or assuming that some of these properties are owned by in-state people and entities, then it's an additional criminal violation to drag them into court to say, really, we mean it, we don't want to do this, we don't want to be the property managers.
Okay, that makes sense to me, and I can support that. Thank you.
Seeing no further lights, I'm still, I understand where we're going. I'm not sure it goes far enough. I would just as soon have more time and have staff come back and answer the questions that were posed today, and I am not comfortable with having the owners, property owners in this ordinance, so I will not be supporting this at this time. Just have that on record. I don't think I have a motion, do I? Got a motion by Laurenti to approve, second by Drew. Any further discussion? Seeing none, all in favor? Aye. Any opposed? Aye. Vote carries 3-1. The one no vote is myself. And then prior to concluding today's meeting, I was given notification that it's kind of sad. Today is Maggie's last time visiting us and taking our minutes for the Legal and Finance Committee meeting. So I'd like to personally say thank you, and I will miss you, Maggie. And if there's any other comments from any of the other committee members. With that being said, we're ready to adjourn. I'll entertain a motion to adjourn. Motion by Nordstrom to adjourn, second by Laurenti. Any further discussion? Seeing none, all in favor? Aye. Any opposed? We're adjourned. Thank you, everyone.